Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. It's a pleasure for me to introduce the second of the series of the presentations related to the basic overview of major sanctions regimes. And today we will talk about UN sanctions. And as always, a short reminder that this presentation is for general purposes only, serves as a starting point in a sanctions analysis, and does not constitute legal advice, which has to be sought given your specific circumstances. So what we will discuss today are a few points. We will talk about the key elements of the UN legal framework, which introduces the UN sanctions. Then we will talk about basic decision-making process, where different UN bodies are involved. We'll briefly touch about current sanctions regime and their classification, just to have a little bit better idea about what the UN sanctions are about. And then the practical application of the UN sanctions vis-a-vis member states and private persons, and the remedies which the private persons affected by the UN sanctions may have in the United Nations decision-making bodies and in the courts of national jurisdictions. So the starting point would be to consider the legal framework of the UN sanctions, where the major provisions are set out in the UN Charter, and in particular, the most important provisions for the purposes of our presentation are set out on the slide, where Article 103 of the UN Charter sets out the precedence of the decisions of the UN Security Council in particular, which would be the most relevant body for the purpose of the introducing and managing the UN sanctions program, but also the UN Charter itself. So to the extent there is any inconsistency between the provisions of the relevant resolutions of the UN Security Council and other obligations of the states, the resolutions prevail, and the states have to accord their general behavior in accordance with the provisions of these resolutions. So the first point to understand is that in the supremacy of in the hierarchy of the obligations of the international community, the UN sanctions program take precedence over any national sanctions program, at least as far as the obligations of the states are concerned. The second major pillar of the legal framework is very broad discretion of the UN Security Council granted pursuant to Chapter 7 of the UN Charter with respect to taking measures which are of a non-military nature, so these are not related to the use of armed force, but which purpose is to contribute to peace and security. Those powers of the UN Security Council are granted by Chapter 7 powers, which are of a binding nature, and more specifically Article 41 of the Charter, which sets out the broad powers of the UN Security Council to take measures which are of non-military nature, and secondly, the introduction of economic sanctions would be such measures. So whenever the UN Security Council acts with respect to the introduction of the new sanctions regime, it acts pursuant to its powers granted under Chapter 7 of the Charter. Now we would consider the specific procedure which exists at the UN level with respect to the introduction of each sanctions regime. On the basis of those provisions of the UN Charter, which we've just considered, each specific sanctions regime will be introduced by the resolution of the UN Security Council made pursuant to Chapter 7. Like with any other resolution of the Security Council, the regular provisions for voting would apply, and this requires that 9 out of 15 members of the UN Security Council support the resolution, and there is a concurrent vote of each permanent member of the UN Security Council, which include China, France, Russia, UK, and the United States. So this voting procedure, whereby all 5 members have to concur, meaning they have either agree or abstain, means that each of them can block the relevant resolution, which introduces the UN Security Council sanctions regime. And for that reason, for a very long period of time, there were very few sanctions regimes introduced at the UN level, because there was a general disagreement between the permanent members as to relevance and usefulness of sanctions for the achievement of the specific political objectives. As there is more and more consensus at the UN level between the permanent members, the sanctions regimes were adopted in accordance with the voting procedure and the provisions set out in each relevant UN Security Council resolution, which would be pretty detailed documents setting out specific restrictions following out from the relevant sanctions regime, which we'll consider a little bit later. The role of other bodies of the United Nations, the Secretary General, the UN General Assembly, the International Court of Justice, in the administration of the UN sanctions is limited, mostly limited to declaratory statements, which are often stated at the UN General Assembly, arguably to the extent they represent the consensus among international community. Some of those statements may be elevated to the level of customary international law. Having said this, as of today, arguably no sanction regime and no sanction position would amount to customary international law. So what we're dealing with are the UN Security Council resolutions, and the UN Security Council being the primary and maybe the sole decision-making body at the UN level. Currently, UN administers various sanctions regimes. Here I summarize them in the first bullet on the slide. As you can see, they largely address two situations. The first situation, geographical situations within specific states. This can relate to the situation in the state as a whole, as, for example, relates to the North Korea, or some specific geographical area within the state, as the case of Darfur region in Sudan. And then there are some non-state actors, which are also the subject matter of the UN Security Council resolutions, like ISIS or Al-Qaeda. And there are also subject matters which are unrelated to either state or non-state actors, like the issues related to the non-proliferation of weapons of mass destruction. The way each Security Council resolution introducing the sanctions regime operates is that there would be the substantive provisions, meaning that the resolution will set out those restrictive measures which the sanctions regime purports to apply. And then there would be a permanent committee set with respect to each regime, which will actually ensure the day-to-day administration of that regime, meaning more specifically listing and delisting of specific persons, which are subject to the sanctions, dealing with their applications for exemptions, and dealing with other day-to-day matters. Each committee mirrors the composition of the UN Security Council, so the representation of the committee consists of the same states which are members of the UN Security Council, with the exception that the decisions of the committees are made unanimously rather than in accordance with the voting procedure of the UN Security Council. Then each committee will maintain its list of designated persons, and day-to-day documents and the resolutions and the other statutory acts which are relevant for the work of the committee, which is available on the UN website. As to the nature of the UN sanctions, these are largely targeted sanctions, with the overall idea that the sanctions program shall focus on specific individuals and specific matters, rather than aiming to interrupt general trade relationship with countries, with the view to minimize effect of the sanctions on those persons who are not directly involved in the questionable behavior which the sanctions purport to address. And among more specific measures of those targeted sanctions, I list here the common and uncommon measures, which occasionally appear in the UN Security Council resolution. The listing of persons, which de facto would mean that the funds of these persons shall be frozen in the UN member states, as well as no economic resources shall be made available to these persons, is one of the most common sanctions. Then the list of the persons who are subject to the sanction will be established by the relevant committee. Arms embargo is certainly a common feature of almost every UN sanctions regime, given that the overall objective is to contribute to peace and security. That's not something which is surprising. Comprehensive economic trade sanctions would be uncommon today for the reasons which I've just explained. The focus of sanctions, including at the UN level, is shifting more towards targeted, more individualized type of restrictions. Having said this, there are still examples of the countries like the North Korean sanction regime, where their restrictions are so broad that they would come close to a comprehensive economic trade embargo imposed against this country. Restrictions with respect to trade in non-military goods would not be common and primarily relate to those situations when the trade in certain specific commodity is believed to constitute a source of income for the ongoing conflict. And then the logic is that by cutting that source of income, the conflict will be resolved, or at least the substantial contribution will be made to the resolution of the conflict. A few examples of this type of sanctions will be the restriction on the trade in charcoal, which is supposed to be one of the sources of income for the ongoing sectarial violence in Somalia, as well as the crude oil trading restrictions with Libya, which were imposed following the fight which is currently ongoing in Libya between the governmental and non-governmental forces, and which in essence prohibit the trade in crude oil, in Libyan crude oil, and non-governmental forces, which are not recognized by the United Nations as representing Libya government. And then there would be certain other restrictions on a case-by-case basis, tailored by the UN Security Council resolution with a view to achieve peace and security in a specific region. Again, this would not be common, but rarely met. All of those will be set out in the UN Security Council resolution introducing the relevant regime. So here, by way of example, I just set out the restrictions which are applicable to the situation in Sudan. And here we can see in the first restriction the standard arms embargo provisions. As you can see, it's not comprehensive, so it's not related to the entire territory of Sudan, but to the situation in Darfur. So the destination is important for the purpose of the arms embargo. And then the other sales of arms are in principle permitted, subject to the clear purpose and compliance documentation by the relevant exporter. Which again means that it would be a little bit simplistic to say that arms embargo with respect to country means that the complete trade is prohibited. As we can see when with the situation to Sudan, there are nuances of this matter. Then there is the standard freeze sanction with respect to those persons involved in the conflict and contributing to the conflict, and the travel ban. So the sanctions against Sudan would fall within those three main categories of targeted sanctions, which we set out in the first bullet, and would include the asset freeze against individuals, travel bans, typically with respect to the same individuals, and then arms embargo with respect to the country. And as you can see, we don't see any other sanctions here, which would restrict trade in non-military commodities or would impose some other types of restrictions against the country, which again, logically speaking, is very consistent with the overall purpose of the UN Security Council, which is to establish peace and security. As to the legal nature of the UN Security Council resolutions, 2 points have to be distinguished. The first is the legal effect of the UN Security Council resolutions on the UN member states. And the second is the legal effect of the same resolutions on the private persons operating within the member states. As to the first point, the matter is legally quite settled. The UN Security Council resolutions are binding on the member states. And accordingly, the member states have to comply with them. And as we discussed at the beginning of the presentation, these obligations of the member states will prevail under international law or any inconsistent obligations. And so accordingly, each UN member state, which by now is almost every country in the world, has to adjust its behavior in accordance with the UN Security Council's resolutions. The question of whether these resolutions create direct obligations for individuals, so to which extent, for example, banks in the member states have automatically to comply with the UN Security Council, for example, restrictions imposing an asset freeze on specific individuals, is a more complex question to answer, because the answer will depend on the laws of the specific jurisdiction and whether that jurisdiction would recognize the UN Security Council resolutions as creating direct effect for the private individuals, or whether certain implementation measures will be required at the national level to give effect to those resolutions. As far as the European Union is concerned, at least the position is quite clear. The UN and the European Union coordinate their sanctions program. So the European Union committed to implement each UN sanction program within 30 days period and within short periods to the extent that relates to terrorism. And from that perspective, every Security Council resolution will typically be shortly followed by the relevant decision of the Council made within the framework of the common foreign security policy of the European Union, and then the UN, and then the EU regulation, which would have direct effect within the territory of the European Union. The bottom line of this is that, whilst legally this may sound a bit complex, the net practical result of this is that every UN sanctions regime will have direct effect within the European Union and will create direct obligations for the relevant individuals with respect to their day-to-day operations. A word of caution: whilst the European Union has to replicate certainly the provisions of the UN sanctions resolutions, it so happens sometimes it takes one step forward. So, for example, it can add additional individuals to the list. It can restrict different additional sectors of economic relationship with the relevant jurisdictions due to its inherent powers. So it would typically be not sufficient for the purpose of establishing the effect of the UN sanctions within the territory of the European Union to read the resolutions of the UN Security Council. But it would be necessary in the first place to familiarize with provisions of the relevant EU implementing regulations, because these would be the laws for private individuals and companies of day-to-day relevance. And for the reasons which I've just explained, they could be different in substance from the UN Security Council resolution. So bottom line, to the extent you want to understand what is the scope of your obligations with respect to certain transactions which may involve the jurisdiction subject to the sanctions restrictions of the UN level, the first point would be to identify the relevant implementing EU regulation, and then to ascertain from that regulation what are the rights and obligations of the relevant persons. So Luxembourg is an EU member state, and in this respect, all the EU implementing regulations have direct effect within the territory of Luxembourg and are mandatory for the persons, for the nationals of Luxembourg who operate within the area of the state. And in addition to that, the national laws of Luxembourg require that the private individuals give effect to the UN Security Council resolution. So this provision also makes them mandatory for all operators and nationals within the territory of Luxembourg. Turning to the last point, which I would like to address today, is the issue of what may be the methods and channels for a private individual or a state which is affected by the UN Security Council resolutions imposing certain sanctions restrictions, either on a person individually or generally in the state, to challenge these resolutions, to challenge the designation, for example, to ask for an individual exemption in the circumstance when those exemptions are permitted. And here, the bottom line of today's status quo legal regime is that the first and primary channel for addressing this type of matters is the administrative revision regime of the UN Security Council resolutions, which would be typically established by each relevant resolution itself. And the way these regimes function is that the committee which administers the UN Security Council resolution regime would be the primary responsible focal point for this type of requests. So whenever an individual has a request for an individual exemption, or whenever an individual has a request for delisting, this matter has to be administratively addressed by the body which is established by the UN Security Council. At the level of the United Nations, there is limited opportunity to do anything else for private individuals because no judicial review mechanism is established with respect to the UN Security Council resolutions, which would include also those resolutions which we discussed in today's presentation. The situation is slightly different at the level of member states. Whilst there was a period of substantial uncertainty where the national courts would have the jurisdiction to review the obligations coming from the UN Security Council resolutions, given the primacy of those obligations under international law. It was eventually established by the Court of Justice of the European Union in the Cadi case that these limited reviews shall be permitted for the purpose of ensuring that those resolutions do not affect the basic and fundamental rights of the individuals. So this limited review is permitted. Having said this, the de facto situation remains that it's extremely complex, cumbersome, and lengthy procedure. And other than Cadi, there's probably no other example when the designations under the UN Security Council resolutions were successfully challenged. And even in those circumstances where they were challenged, the matters related to the manifest error of assessment of facts and are highly unlikely to go over this area. So that's for today. Thank you very, very much for watching.